Johnston.
Thank you, Madam Speaker. Madam Speaker, I also rise to speak on this bill. We know this bill touches on 4 separate acts, and while it's been described as administrative housekeeping, actually some of these changes have real consequences for real people in our community. I want to talk briefly about the Firearms Act changes. We know these propose that cutting the waiting time for acquiring additional firearms from 28 days down to as little as a few days. We've heard that as long as you already own a gun in the same category and the checks are done, that should be okay. And I want to be clear, I'm not anti-firearms. I know many people own and use firearms legally and responsibly for legitimate purposes. But just because someone has a genuine need for one firearm doesn't automatically mean they have a genuine need for 5 or 10 or 20. And in the Northern Territory, there is no limit on how many guns you can own. We heard the member for Goyder say that in terms of the 28 days, it was just I can't remember what word he used, but it was something that was not kind of made up. That wasn't the word he did, not based on anything, but actually the 28-day cooling period isn't just bureaucracy. It's a safety net. It's based on national firearms framework. It's a time for police to do thorough checks. It's a time where circumstances might change when people have a potential deadly weapon in their hands. Some people may argue that if all checks are completed, that 28-day waiting period is unnecessary, but that's a misunderstanding of its purpose. When I talk to people who work in this area, they explain that this is a critical safety buffer because even when all administrative checks are done, circumstances can change quickly. A person may become subject to a new police investigation, experience a mental health crisis, or engage in violent behaviour that wasn't previously recorded. That 28 days acts as a pause button, giving police time to identify emerging risks and protect our community. I recognise that someone who already has a domestic violence order cannot legally acquire another firearm, but I think everyone in this chamber knows that many perpetrators of domestic violence do not have a formal order against them. Many women do not take out orders because of fear of retaliation, because of financial dependence, because of isolation, because of cultural pressures, because of trauma. So the absence of an order in no way means that a person is safe. It only means the law has not yet recognised the risk. Under these proposed changes, a perpetrator without an order could acquire multiple additional firearms in a matter of days, even after all checks are complete. In a practical sense, someone with a history of abusive behaviour but no order could quickly stockpile firearms, putting women, children and communities at serious risk. It's unclear why we should be putting people at risk. For what benefit? I don't understand what the rush is in this. I'm sorry if someone has a lot of guns on lay-by, but when I balance that up with putting women and children at risk, it just doesn't add up. I'm calling on the government to maintain the 28-day waiting period for all firearms acquisitions, regardless of what you already own, because community safety must come first. The other thing I want to touch on, which we've also heard about today, is the amendments to the Information Act, kind of buried there in Part 3, which we know would exclude communications between ministers and their staff from FOI requests. We got told, don't worry, this already happens. Because something already happens doesn't mean that it's okay and we should put it in the law. We know that right now there's a court case, but the government's been very open about the fact that there's a court case trying to access historic documents about the McArthur River mine involving Nicole Mannison, who was Deputy Chief Minister, Treasurer and Minister for Mining and Industry when key decisions were made about that mine, and who now works for Tamboran Resources, the same company that holds the largest acreage in the Beetaloo Basin, and the McArthur River mine, operated by Glencore, which also has major interests in the Beetaloo Basin. And the government's been clear that they're changing this law to shut down that court case to make sure Territorians never see those documents. That is exactly what this amendment does. I'm shaking my head because it's unbelievable to me the blatant disregard for Territorians having access to information about how decisions are made that affect them. They're openly saying, we just don't want you to see this. In practice, for people in my community, someone might come up to me and say, Justine, can you help me find out why the minister made a decision that's affecting my community? I put in an FOI request and the government said, sorry, that's just ministers talking to their staff, not your business. How do we know if something's official portfolio business if we're not allowed to see it? How do communities hold their government accountable when the government decides what we are and aren't allowed to question? For example, when residents in where I live raise concerns with me about air quality, whether it's about East Arm Port, industrial emissions, or dry season smoke, they want to know what monitoring data ministers received, what discussions took place about health risks, why certain decisions were or weren't made about air quality standards and about public warnings. Under these changes, much of that discussion could simply be declared ministerial communications and hidden from view. That's not good, accountable government, that's government in the shadows. I'm calling on the government to withdraw these Information Act amendments entirely, because if you believe in transparent and accountable government, as you say, you don't need to hide your communications from the people that you serve. Madam Speaker, the other parts of this Act I will be supporting, but I do not support the Firearm Act changes. I strongly oppose the Information Act changes. They're not just technical changes, they're changes that have potentially have a fundamental impact on real people in my community and people across the Northern Territory. The single mum who hasn't been able to take out a DVO but is terrified that her ex-partner can quickly stockpile firearms. I'm sure anyone in this chamber who's worked with women who've been at threat of violence will have heard a story like this. So I call on the government to maintain the 28-day waiting period, to withdraw the Information Act amendments, because the people of the Northern Territory deserve a government that operates in the open, takes their safety seriously and genuinely serves their interests. Thank you, Madam Speaker.
Are there any other speakers?